Welcome in, everybody, here to Queen City News Plus as you are watching Order in the Court with anchor Brian Blakely.
And I'm Chief Legal Analyst Khalif Rhodes.
Oh, man, good to see you. How you been?
Blessed, man. Blessed.
All right. No wrestling for you? What's up with this big winter storm we got coming in?
This winter storm is freezing, unintended, everything. So we're doing absolutely nothing.
Putting a freeze on everything, and I just got back from Palm Springs and a baseball tournament out there. It was awesome.
Welcome back to cold weather.
Cold weather. Well, you know what? Court is in session. Let's talk about it because they were inside today in Washington, D.C. at the Supreme Court. Opening oral arguments today were heard regarding the Federal Reserve Governor Lisa Cook and her job there. And right now, President Trump, he's been trying to wrest control away from the central bank. Supreme Court heard the arguments today. And from what we heard, they seem like they're inclined to side with Lisa Cook.
Fireworks. That's what I heard. I heard nothing but fireworks in there. So let me tell you this. As an attorney, people may think you like listening to oral arguments, and these are, what we spend as nighttime reading and watching. No, absolutely not. Most of the time, they're boring. They're dry. That was not the case today. If you have an opportunity to go and listen to them, I would highly recommend listening to oral arguments from the very beginning. The Solicitor General comes out firing as to why they believe that the president should be unchecked in his attempt to fire Lisa Cook.
And they're trying to fire her, by the way, because they say that she committed mortgage fraud. And Trump's efforts, and the president, he wants to fire her, and he also wants to get rid of Jerome Powell as well.
He does want to
chairman.
He wants to do a number of those things, but hovering around Cook, there was a lot of pushback to this entire process. You had folks that I wasn't even anticipating that had pushback. Justice Alito came out and said, hey, why is it so expedited? Why does it seem so rushed? Why are we doing this on an emergency basis? And why do we need to do it so fast? But I
question on that real quick. Why did the court decide to hear that then? If they're questioning that in court, why did they take it up in the first place?
Well,
who decides that?
You have a lower court decision that was made. There was an injunction that was made. And then in between the injunction being made, immediately after that, the Solicitor General, they go out and request an immediate appeal to the Supreme Court for what that lower court injunction ruled. And they granted cert to hear it on an emergency basis, specifically not addressing and listening to the main argument, but just really looking at the what the lower court ruled. And Justice Sotomayor said that. She went through and said, well, you guys are here and you listed a whole thing, a bunch of things that you want to talk about today. But did the lower court even get an opportunity to address that? And so then I like that the Solicitor General came back and said, well, it was unprecedented to see them enter and grant a injunction in a situation like this. And then the justice came right back and said, well, in the 120 plus years of the Federal Reserve, never in the history has a governor been removed. So she said, if anything is unprecedented, it's the removal of a governor while still being seated. And that is the back and forth nature. It was like tennis listening to the arguments. And so I want folks to recognize at home, putting it in perspective, Congress established the Federal Reserve Board. And I often say that a lot of times Congress is reactive. Something bad happens, Congress reacts. Laws are created, and then we move on. Well, that's exactly what happened. In the 1800s, you had a number of financial crises back to back that occurred. And so they said, we need to have infrastructure. We need to have something that can be established that gives us a central banking system where people will have trust in the process. 1913, they established this, and now we have had this system for all this time. You mentioned a number of things about Cook, the allegations that the Trump administration is making, specifically that she's alleged to have done mortgage fraud. Her team comes back and says, wait, what you're alleging is an error that was on a document. And if you're going to say that error was something that was fraudulent, was deceitful, was done maliciously, well, they pointed to multiple members of the Trump administration, 4 of Trump cabinet members, his deputy attorney general, the individual that brought this claim, Bill Pulte, a number of other individuals have done the exact same thing or alleged to have done the exact same thing, and no charges have been brought. They're saying selective prosecution is what happened in that regard. But I think there were some very, very good quotes in here. When asked about the errors that were done. Chief Justice Roper said, well, any misrepresentation about residency were part of a stack of papers that you have to fill out. And so if there was an issue there, they were contradicted by all of the other documents that were in the record. Brown Jackson says that the factual record was incomplete, kind of agreeing with Justice Alito that you're asking us to do this fast without even having an actual fully run hearing. But Justice Kavanaugh had the best argument of the day. During her argument, he says, warning that allowing the president to fire a Fed governor on such grounds could weaken, if not shatter, the independence of the Federal Reserve. And
point out also on Kavanaugh, he is a Trump appointee with one of the three that are on there with Gorsuch and Amy Coney Barrett.
Well, I will tell you this. Barrett was right behind him. She said, well, aren't you supposed to get a formal process? How are we moving forward without her getting a hearing in a formal process? And so they made the assertion that there is no requirement for her, Cook, to receive notice in a hearing. And they argue that even if she was required, that her notice was given by the social media post. So we're seeing a number of things that are happening in these hearings that are not normal, and that our technology is catching up with the legal system, because for them to say that her notice was his social media post and she had opportunity to be heard in the 5-day period and she's never addressed it, she had public opportunity to address it, and because she's failed to address it, that's given President Trump cause to fire. Those are the number of things that happen in today's hearings. And what I can tell you is absolute fireworks. I mean, that Solicitor General was on his toes the entire time. Sauer was making a lot of arguments, but it's been rare to see most of the justices come at a Solicitor General like that. And today they had him bring his A game. And so it was absolute fireworks.
Yeah, you're talking about the justices there, and you talked about tea leaves earlier, saying many of them, 5 of them, of the 9-member court sounded very skeptical. When could we see a decision from the court on this?
I mean, I think in the next few months. These are typically that 5 to 6 months.
Not June or July like we normally do for a lot of this.
We're still in the month of January, so June or July would be a typical time frame that I would say. But if you walk away with anything from this, recognize that past all of the smoke and mirrors, and this is what the justices wanted Sauer to understand, we still need to talk about the hearing process. Did she receive proper notice? Does she require a hearing? And if so, was it given? And if it wasn't given, you've now violated this due process, regardless of the injunction and everything else you're asking and going to the under issue that's there. They still need to recognize, have you given notice? And the social media post is being held to not be noticed. And they even gave a couple scenarios like, so what was her notice? Over a table, listening to him talk to her about it, and then 2 minutes later, okay, now you're fired. There were a number of back and forth scenarios of trying to flush out what they thought would be adequate notice. But Sauer stood on and believed that, A, there was no requirement to give notice because he's the executive, and basically the court is now telling the president when and who and how he could fire someone. So I think if, as you mentioned, the tea leaves, I think the writing is on the wall that they will be inclined to say the president does not have the authority to do this and kick it back down to the lower court to have a full hearing.
We will certainly be following that one. That is the end of our first segment here on Order in the Court with Khalif and Brian. Coming up, we're going to be talking about Minnesota. DOJ subpoenas Minnesota officials. We'll have more on that on Queen City News Plus. You're watching Order in the Court. Welcome back to Queen City News Plus, and we're having Order in the Court with Khalif and Brian. Second topic today, Khalif, we're going to be talking about, and that is the Justice Department have subpoenaed at least 5 officials in Minnesota, and that is including Minnesota Governor Tim Walz and also Minneapolis Mayor Jacob Frey, as a part of a probe into where the local and state leaders there have obstructed the federal immigration enforcement officers in their efforts on the immigration crackdown. It also comes 2 weeks after the shooting death of one of the protesters there.
Yeah, what they're asking for is, if we believe that you have obstructed a federal operation, we're going to want to, talk to you, or also want to see documents. We want to see text messages, emails, any type of communication that was written so we can prove our case. I'd pull up 18 U.S.C. 1505 in 18 U.S.C. 371 as the conspiracy to impede federal officers in the obstruction of proceedings as the case law as to what they're attempting to say these folks did. You got 4 points. First, that there needed to be federal action that existed. Well, we know federal action existed. There were officers on the ground, ICE agents, Homeland Security, immigration officials were there in Minnesota, in Minneapolis. So there was lawful federal enforcement. And I also want to be clear. There's no mistaking that immigration, the issue of immigration, is clearly codified in case law, in constitutionally, that this is in the grounds and in the concept of the federal government. The states have no control over immigration, so this is a federal issue. So federal action clearly existed. So now the other question is defendants knew about it. Well, state and local officials knew that federal actions were there. They knew about ICE operations. It's clear they would have had to been blind to not know that ICE agents were in their state then when this was happening. These are the two I think are going to be the hardest for the government to prove. Intentional interference, that the officers, these 5 folks that they've subpoenaed, that they've now asked to come and speak, they acted with intent to obstruct or hinder that operation. It's not enough just to disagree politically, but you have to have done something or wanted to do something or spoke about doing something to intentionally interfere. And then the last one is you did an overt act. Okay, we went past talking, we went past texting and writing, but now I'm out on the street. I've got a group of people. I've got van loads of folks. I've done something to stop their efforts. And if those are able to be done, then yes, if you created policies that have blocked federal agents, if you provided material support that undermines federal enforcement, then yes, they'll be able to get you on those obstruction of federal operations. And I think that is what they're going after. It's can they prove those last 2 keys, and in subpoenaing records will help them get there.
Yeah, and this has certainly been a powder keg here in Minneapolis with a lot of legal maneuverings back and forth because Minnesota authorities there, they have been shut out of the investigation into the shooting death of Renee Good a few weeks ago by one of the immigration ICE officers there. And so the critics are denouncing the DOJ's handling of that investigation. And Jacob Fry, the mayor of Minneapolis, that requires him to appear in U.S. District Court coming up on February 3rd. He has accused the federal government of weaponizing their power to intimidate the local officials like him to pretty much stand down.
And that's where the reason that they're there, the Trump administration is already calling them sanctuary cities. But case law has already said a number of cases that sanctuary policies doesn't equal obstruction. So even with them attempting to go after Mayor Fry, him and his team will be able to point to a number of things. Supreme Court precedent is major in an obstacle for the Department of Justice. First case, Prince v. United States, argued in 1997. States cannot be compelled to assist federal enforcement. So if you're telling me that the federal government is coming, as long as you're not doing anything to stop them, to obstruct them, you don't have to assist them. So your requirement, it only means don't stop us. Don't hinder. Don't stand in the way. But it doesn't say stand with us. It doesn't say you must assist. And because they're attempting to say you guys have these sanctuary policies that don't allow your officers to assist us, now somehow you're obstructing. I think that argument's going to be hard to prove. Additionally, Murphy v. NCAA, federal government cannot commandeer state officials. So because, again, you're attempting to have this federal enforcement and you're here in our state, in our city, in our areas, you now can't make all our agents, our local officials work with you. And so those will be the 2 issues. And yes, when Fry goes in those hearings, he'll have to do that. But there's other things that are happening in Minnesota. The U.S. District Court judge issued a preliminary judgment limiting the types of things that we're seeing on the screen now. The federal judge barred federal agents from arresting or using tear gas or other crowd control weapons against peaceful protesters or bystanders. It also prohibits agents from detaining or retaliating against people who are just observing or peacefully demonstrating. This applies, lawsuit continues to tie specifically to agents involved in the operations there in Minnesota and Minneapolis. So what I can tell you is there's a number of litigation that will continue to go in this state. While they're there and even after those agents have left, these cases will continue to be litigated. But that case that was brought through by the ACLU, it was by an individual that had they believed their federal rights were violated by ICE agents, and the court said this type of effort, these type of things cannot go forward.
All right, that's the story we're going to keep following, too, especially coming up on February 3rd there when you talk about that when Jacob Fry, the mayor of Minneapolis, will be subpoenaed. We'll see if he does follow through with that. Other story that we're following here today for our last segment is this guy, Darian Mensah, the quarterback at Duke, who had a great year, won the ACC championship. I was at that game, but a lot of legal issues right there. We're going to talk about that on Queen City News Plus Live coming up after the break. You're watching Order in the Court. Welcome back to Queen City News Plus, an Order in the Court here today with Khalif and Brian. And our last topic that we're going to talk about is this young man right here, and that is the quarterback of Duke, Darian Mensah. He, star quarterback, he is wanting to transfer now out of the transfer portal. The problem is he signed a deal to go to Duke last year after being at Tulane, a deal where that was 2 years for $8 million to keep him there. And now he wants to get into the portal. That breaks the contract. Duke is suing him because they don't want to let him leave. Give me the breakdown of all this and what's going on from a legal perspective of what can you do and what's going to happen out of all this.
Breach of contract is the issue, but I'd step back even a step further. And so when he gave the school his notice that he wanted to leave, Duke did not put him in the portal. So his team went and got an injunction to force them to place him in the portal. That's what sparked this 44-page complaint that was filed on Tuesday morning by Duke, urging and arguing that Mensah should not be allowed to enter the portal. And they do a couple of things. They're saying you should be going to arbitration. They agreed to the arbitration within the terms of the deal, and because of that, the court should not have entered the injunction, but should allow this to go to arbitration. A couple of things. When you talk about breach of contract, yes, it's a 2-year deal. Yes, it was $8 million. They're saying that we have now your name, image, and likeness rights for the next year because you've already played 1 year, so you are contractually tied in to us as a team. They go on to say, Duke says, contracts mean something. His actions violate numerous provisions of his contract with Duke University and disregard his promise and obligation to the university. What I will say is his team came back and made the argument. You can't restrain the movement of athletes from one school to another. There's no provision in the agreement that removes a requirement that Duke put the player in the portal within the 48 hours of a request. There's no irreparable harm. There's a mechanism in the contract that shows how they be compensated for any harm. Thus, there cannot be irreparable harm. That's what's at play right here. So I'll tell you this. This will come down to the four corners of the contract. The document at play will be determining what happens. In law school, they talk about interpretation of contract law, of breaking and binding agreements. They say that there's this four corners process, and you just look at the four corners of the document. I think that you have to see what the agreement said.
This is exactly what's wrong with college football right now. I mean, it is a wild, wild west. What good is a contract worth? We've talked about this with the Washington quarterback, Damon Williams, and the issues that were with him. And then he wanted to leave the transfer portal. He had signed a deal. But now, how does this quarterback, if he has to go back to Duke, does the team want him?
Right.
That's another issue.
Well, they definitely want him, that's for sure. But what I can tell you is another example of flying the plane and building it at the same time. While for years athletes wanted to get compensated and the NCAA stopped that.
Now they're getting it.
Right. Now they're being compensated, right? And they're being compensated on a high level. Some of these guys are making what's, third string quarterbacks are making in the NFL right now.
Money, yeah.
Right. But what I can tell you, Brian, is it's in its infancy. And because it's in its infancy, it's going to take time for the rules to catch up with the playing on the field. And so what I can tell you, suspect what will happen now is you'll have less players signing multi-year deals. You'll have only one type of year deal because if I'm locked in for multi-years, now I'll have, if I want to jump into the portal after I have a big year, I won't be able to because I'll be contractually locked in. Second is there's already language out there that exists, and I can point to the clearest example. Look at what happened with Lane Kiffin. He went down there to Ole Miss, left Ole Miss, and just went to LSU. Within his contract, there was language for a buyout. His school was able to be bought out from their contract with the other school. So as folks get creative with this NIL language, there will be buyout provisions in there. And I'm assuming that's what his attorney is saying, that there's no irreparable harm because there's a mechanism in the contract to show how they'll be compensated. He doesn't go on to say what that is, but to me, that sounds like buyout language. That, hey, I want to go to another team. This other team's offering me probably more money, and part of that money I get will go back to you to compensate you for your loss. That's, I think, the next rendition of what happens with these NIL deals is that now there'll be buyout provisions in there because you don't want to be tied to a team specifically if someone's offering more money. And we can't really blame the athletes because it's happening at all levels of the sport.
If I can get the money, go get the money, right? Yeah.
And if it wasn't happening,
right? Those guys aren't going to get the money in the NFL, so why not get it in college?
It's extremely less likely that these guys are going to go and get massive contracts in the NFL. And so if your earning potential is there on this collegiate level, some of these guys have the earning potential on the high school level. You want to capitalize.
Which is next.
Right. You want to capitalize when your earning potential is there.
It's already here, actually, especially with a couple of
It's
people.
here.
Yeah, the quarterback out of Winston-Salem, we saw is going to Tennessee.
In North Carolina quarterback right there.
Grimsley. So one of the questions I wanted to ask you about is this as far as the legal perspective where Darren Heitner, who's the lawyer for Mensa, he said a judge in this case will allow Mensa to enter the portal, and he said it on social media. There's an injunction in front of a new judge who has no known ties to Duke. That's scheduled for February 2nd. He wants to move that up. In the meantime, the prior judge indicated from the bench that he will deny Duke's request.
Yeah.
To
I can give you a quick answer. Yeah. He went through the irreparable harm standard, what I just mentioned. Likelihood of success on the merits, no irreparable harm, balancing of the public equities, and it's balancing in the public interest type of scenario. So you go through those four factors. The likelihood of him being successful on the merit, the judge that heard this originally must have seen the contract and recognized that there's language in there that allows him out. The irreparable harm is simple. Is the harm going to be something that money can't fix? His attorney is saying money can fix it. Mm-hmm. If you don't want him to go to another team, there's specific language in here that compensates you for your loss. So what he's saying is your injunction to stop him from going into the portal should be denied. Why? Because this is not irreparable harm. That is a clear injunction standard. Going through that is typical. And an injunction also is an extraordinary remedy. Courts don't want to enter injunctions. They want you to work these things out in the case in chief. They don't want to go and do these side hearings, then do something temporary so that you can hear your case and then lift the injunction. They want to be able to hear the case in its entirety. So it was a stretch for them to be able to get that anyway. But this is what I can tell you is Young Money's who represents this, or Young Money Agencies who represents this young man. That's the rapper Lil Wayne's agency. So he's tapped his foot into this sport and attempt to try to, find ways to represent these athletes. But right now he's spending a lot of money in legal fees.
Yeah, and legal fees to get probably another payday somewhere else. And
probably.
Yeah, it's a story that we're certainly going to keep following. A lot of Duke fans here in the Carolinas, they want to know if they're going to have their quarterback back at Duke next year or not. Likely seems like it won't be. He'll be going to another place. And that is today's landscape of college football, is you can only expect some of these stars to stay at one place. They're going to go get paid somewhere else. All right, you've been watching Order in the Court with Khalif and Brian, and appreciate you. And we're going to wrap it up here as court is not in session anymore. You're watching Queen City News Plus.
Queen City News Plus. Just search Queen City News on your smart TV's app store.